Hey, look at this table. A New York bagel next to a Venezuelan arepa. Does this combo make sense? Not really, right? But here's the thing. This weird pairing is exactly what happened in Manhattan Federal Court. Picture this. Nicolas Maduro, Venezuela's president, gets charged in New York. Not Washington, D.C., not Miami, New York. You might be thinking, wait, why New York? Isn't that just random? Let me tell you something crazy. The choice of location wasn't political theater. It's actually a criminal procedure technique that most people never hear about. Today's story has three mysteries that sound impossible. First, how can where you hold trial be a legal trick? Second, can you kidnap someone and still put them on trial? Sounds illegal, right? Well, buckle up. Third, is presidential immunity actually about law, or is it more like a switch the government controls? Before we dive in, let me ask you something. Have you ever heard of venue in criminal law? No? Perfect. Because that's exactly where our story begins. In a courtroom geography, most lawyers barely understand themselves. All right, so here's the first big question. Why does the Southern District of New York matter so much? Let me show you something. This is a map. Crime happens here in Caracas, Venezuela. Trial happens here in Manhattan. See the problem? These places are thousands of miles apart, so how does New York get to decide anything? Here's where it gets interesting. There's this federal law, 18 U.S.C. Section 3238. Sounds boring, right? But listen to what it says. For crimes committed on the high seas or outside any state's borders, the trial can happen in the district where the defendant is first brought or arrested. Did you catch that? First brought. Those two words are everything. They basically mean whoever grabs you first picks the battlefield. Think about it. If federal agents bring Maduro to New York first, boom. New York becomes the venue. It doesn't matter where the alleged crimes happened. What matters is where the plane landed with him on board. Now, why would prosecutors want New York specifically? Let me tell you about SDNY's reputation in one word: experienced. This court has handled massive drug cases, terrorism prosecutions, money laundering rings. It's like the mega court for international crimes. The judges know the game. The juries have seen it all. The prosecutors are specialized. It's their home field. So venue isn't just about geography. It's about who you're fighting and what weapons they have in their arsenal. Can you see how powerful this is? The moment they bring you to New York, the game board is set. Okay, so we know where the trial happens. Now let's talk about what Maduro is actually charged with. The indictment isn't just one charge. It's structured like a three-layer cake. Let me break it down for you. Bottom layer, narco-terrorism conspiracy. That's 21 U.S.C. Section 960A. This is the foundation of everything. What's narco-terrorism? It's when you mix drug trafficking with terrorism. You're not just selling drugs for money anymore. You're using drug profits to fund terrorist organizations or activities. That's the legal theory they're running with here. Middle layer, cocaine importation conspiracy. 21 U.S.C. Section 963. This is about bringing drugs into America. The government claims Maduro's regime facilitated cocaine shipments heading toward the United States. Tons of it, allegedly. Top layer, weapons charges. 18 U.S.C. Sections 924C and O. Machine guns and destructive devices. These charges are the icing. They amplify the punishment. Each weapons count can add years to a sentence. Think of it like this. Drugs bring the money. Terrorism brings the severity. Weapons bring the fear factor. Together, these three layers create a prosecution framework designed to maximize potential prison time. We're talking decades minimum, but here's what you need to understand. This isn't just about proving he sold drugs. It's bigger. They're saying he used state power to run a narco-terrorist operation. That's a sitting president weaponizing his government for drug cartels. If proven, that's not just criminal. That's turning an entire nation into a criminal enterprise. Can you imagine that? Now comes the wildest part of this story. And I need you to pay close attention because this flips everything. Maduro claims this wasn't proper extradition. He says in the dead of night, he was snatched from home while asleep. Pure abduction. You'd think that would void the trial, right? That the court would say, nope, this is illegal. Case dismissed. Wrong. Dead wrong. Because American courts have a doctrine that says the opposite. And it's been around for over a century. It's called the Ker-Frisbie Doctrine, named after two old Supreme Court cases, and here's what it says, basically. How you got to court doesn't matter. What matters is that you're here now. The court has jurisdiction regardless. Let me take you back to 1886. There's this guy named Frederick Kerr. He's in Peru. American authorities want him for crimes in Illinois, but instead of going through proper channels, they just grab him. He gets forcibly taken from Peru to Illinois. No extradition treaty, no diplomatic process, just straight kidnapping. Sounds insane, right? Kerr argues in court. You can't try me because you kidnapped me. The Illinois court has no right. The Supreme Court says, sorry, buddy, you're wrong. The court's power to try you doesn't depend on how you got here. If someone violated laws getting you here, that's a separate problem. But it doesn't strip the court of jurisdiction. Fast forward to 1952. Another case, Frisbie versus Collins. Same scenario, different state. Guy gets kidnapped across state lines. The Supreme Court reaffirms Ker. They say forced abduction doesn't violate due process in a way that destroys jurisdiction. Then comes the really controversial one. 1992. United States versus Alvarez-Machain. This doctor gets grabbed from Mexico. Here's the kicker. There's an extradition treaty between the U.S. and Mexico, but the U.S. doesn't use it. They just send agents to grab him and fly him back. Mexico is furious. The doctor argues this violates the treaty. Supreme Court says, look, the treaty doesn't explicitly prohibit abduction, so the court can still hear the case. Do you see the pattern here? The court keeps saying, we're not condoning kidnapping, but we're not closing the courtroom door either. If there's wrongdoing in how you were brought here, that's a diplomatic issue. Maybe a civil lawsuit. Maybe prosecution of kidnappers. But it doesn't mean the criminal trial against you stops. The jurisdiction door stays open. This is the Ker-Frisbie doctrine. Now apply this to Maduro. Even if he's grabbed in some sketchy way, that might not stop the New York trial. But wait, before you think this is absolute, let me show you where it gets murky. There is a possible exception. 1974, Second Circuit Court of Appeals. That's the circuit that includes New York, by the way. Case name, United States versus Toscanino. And this one asks, okay, what if the abduction was really, really brutal? Toscanino claimed he was tortured, drugged, and subjected to horrific treatment before being brought to the United States for trial. The Second Circuit said something different from Ker-Frisbie. They said, if government conduct is shocking enough, due process might kick in. In other words, if the way you were brought here violates fundamental fairness, the court could dismiss the case. This is huge, right? It suggests there's a line. Cross it, and even the Ker-Frisbie door might close. But here's the catch. Toscanino has never become the dominant rule. Later cases narrowed it significantly. It's more like an outlier. There's even a case the next year, Lugin versus Gengler, also from the Second Circuit, that pumps the brakes. The message becomes, Toscanino doesn't apply to every abduction. It's reserved for the most extreme, outrageous government misconduct. So imagine a scale. On one end, routine abduction. Ker-Frisbie applies, trial goes forward. Other end, torture, brutality. Maybe Toscanino applies. Where does Maduro's capture fall? That depends on facts we don't know yet, and that's what makes this question so explosive. All right, let's talk about the elephant in the room. Maduro is a sitting president. Doesn't he have immunity? Head of state immunity sounds like it should be automatic. Like, you're a president, you can't be prosecuted. Simple, right? Wrong again. Because in U.S. courts, immunity isn't really about what the law says. It's about what the government decides. Let me explain with a famous case. 1997, United States versus Noriega. You might have heard of Manuel Noriega. He was the de facto leader of Panama. He got captured during the U.S. invasion, brought to Miami, and charged. Noriega argued, I was a head of state. You can't prosecute me. I have sovereign immunity. The 11th Circuit said, hold on, were you actually recognized as Panama's legitimate leader by the United States government? Answer, no. The U.S. never recognized him as the legitimate head of state. So no immunity. Case proceeds. See the pattern? It's not about your title, it's about whether the U.S. government acknowledges you as the rightful leader. And here's where it gets even more political. The executive branch can file something called a suggestion of immunity. That's when the State Department basically tells the court, we think this person should or shouldn't have immunity. Courts usually defer to that, because foreign relations is the executive's turf, not the judiciary's. It's a separation of powers thing. Another key case, Samantar versus Yousuf, 2010. This one clarifies that the Foreign Sovereign Immunities Act doesn't automatically cover individuals. Instead, immunity for foreign officials falls under common law principles. and those principles depend heavily on executive branch recognition. So for Maduro, the question isn't just, is he a president? The real questions are, does the U.S. recognize him? And will the State Department tell the court he deserves immunity? Those are the switches that actually control the outcome. One more thing before we wrap up. How can the U.S. even prosecute crimes that happened in another country? This is called extraterritorial jurisdiction. And for drug crimes, there's a specific statute that makes this possible. 21 U.S.C. Section 959. It says, if you manufacture or distribute drugs outside the U.S. with intent to import them, then you're subject to U.S. law, even if you never set foot in America. The drugs just have to be aimed here. And then there's the Narco-Terrorism statute, 21 U.S.C. 960A. This one is designed to hit harder. It targets people who commit drug offenses knowing the proceeds will go to terrorist groups. It's a sentencing multiplier. The idea is, you're not just a drug trafficker, you're funding violence against Americans, so the punishment gets much steeper. This is how the U.S. justifies reaching across borders. If the drugs are destined for American streets, American law applies. Okay, we've covered a lot. Let's bring it all together. Why New York? Because first brought means first advantage. Can kidnapping void a trial? Usually no, thanks to Ker-Frisbie. But maybe yes, if Toscanino's extreme exception applies. Does Maduro get immunity? That depends less on law than on whether the U.S. government flips the recognition switch. So here are 3 questions I want to leave you with. First, should Ker-Frisbie still be the rule in 2026? It lets courts ignore how someone got there. Is that justice, or is that just power saying we don't care? Second, if immunity depends more on politics than law, can we still call it the rule of law? Or is it just the rule of whoever the State Department likes this week? That's a tough one. Third, the moment they bring you to New York, venue is set. Is that a tool for justice or a loophole for power? Think about it. These aren't just legal technicalities. They shape who gets tried, where, and under what rules. That New York bagel and Venezuelan arepa sitting together, they represent a collision of sovereignty, law, and raw political power. Maduro in Manhattan isn't just a legal case. It's a stress test for how far American courts will go, and whether the rules we follow are really rules or just tools dressed up in legal language. After hearing all this today, what do you think? Should courts turn a blind eye to abduction if it gets results? Should immunity be a switch controlled by politicians? Should venue selection be this strategic? I want to know your answer, because these questions don't have easy answers, and that's exactly why they matter. That's today's story. Until next time.